Good morning and welcome. Thank you for coming in today. Today we'll hear oral argument in the case of Stagecoach Group and Coach USA et al. Acquisition of Control, Twin America, STB docket number MC-F-21035. In an effort to move things along, the board members will not be making any opening remarks this morning, but I wanted to cover a few procedural matters before we begin. We have asked each party to make a short statement of their arguments, but counsel should be prepared to answer questions from the board at any time during your allotted time. I assure you that we have read all of your pleadings and there is no reason to repeat every argument. We will have 3 sets of counsel participating in argument this morning in the following order of presentation and respective times allotted. Applicant Stagecoach Group and its subsidiaries and Zev Marmerstein, I hope I got that right, and you have been allotted a time of 20 minutes. We understand that you wish to use 13 minutes for opening and 7 minutes for rebuttal after the other 2 parties present their arguments. If you wish to make a change to your reserved rebuttal time, please advise us when you begin your opening presentation. New York State AG's office will be allotted 16 minutes. Counsel for Continental Guest Service Corp. will be allotted 4 minutes. Speakers, please note that the timing lights are in front of me. You will see a yellow light when you have 1 minute remaining and a red light when your time has expired. The yellow 1 minute light will be accompanied by a single chime, hopefully, and the red light signifying that your time has expired will be accompanied by 2 chimes. Please keep to the time you have been allotted. When you see the red light and hear the double chime, please finish your thought and take a seat. Additionally, just a reminder to everyone, please turn off your cell phones. We will now proceed. Counsel for Stagecoach and Coach USA and Mr. Marmerstein, you have an allotment of 17 minutes for opening. Please step up to the podium, introduce yourself, indicate if you wish to change your rebuttal, time for rebuttal, and then begin.
Thank you, Mr. Chairman. My name is David Coburn. I represent the applicants. I have 13 minutes, I believe, Mr. Chairman.
Thank you. I've just been corrected by Vice Chairman Mulvey.
Yes, and
someone's in big trouble. I wrote that down. Let me tell you.
I hope not.
No.
And good morning, Mr. Chairman and Mr. Vice Chairman and Commissioner Nottingham. With me at council table is Michael Cohn of the firm of Paul Hastings, Janowski and Walker, who's been representing Twin America in the antitrust investigation. The question before this board in this proceeding is one that it has addressed on multiple occasions, and that is whether the board should approve the acquisition of control of a federally regulated motor passenger carrier in the exercise of its authority under 49 U.S.C. 14303. Here, Stagecoach Group and Coach USA, together with one of the approximately 40 motor carriers that they already control, International Bus Service, seeks authority to control a new interstate passenger carrier, Twin America. Twin America was formed by the consolidation of the transportation assets of IBS, which operated under the Gray Line name in New York, and the City Sites entities, the City Sites applicants. The owner of City Sites, Mr. Zev Marmerstein, you did get his name right, also seeks authorization to control Twin America. He needs that authorization because he controls another motor passenger carrier, RW Express, which was the subject of a separate application pending or decided by this board. And the remaining applicant, City Sites Twin, seeks authorization to combine its transportation assets that it inherited, so to speak, from City Sites LLC, an operating carrier, with those of IBS for the operation of Twin America, which is a joint venture. Twin America is a joint venture between IBS and City Sites LLC. The transaction occurred as a result of difficult economic circumstances that are well known to all of us, and particularly pertinent to the tour transportation business in New York, which suffered considerably during the recession.
Can I ask a quick question about City Sites and City Sites Twin? Did either one of those ever get their motor carrier certificate from the DOT at any point in time?
No.
Okay.
They did not. City Sites, which operated as an interstate carrier, we recognize should have had a motor carrier certificate. It did not. We were not representing City Sites. It did not have transportation counsel. It had other counsel who handled transactions for it. I think it didn't recognize that the interstate service that it was providing through joint arrangements with other carriers was in fact interstate and did in fact bring it within FMCSA jurisdiction and board jurisdiction. That may not have been obvious. It was not obvious to the folks who were running the company. They understand it now. And through Twin America, they've applied for FMCSA authority, which they have.
Well, the thought is now that City Sites and City Sites Twin are essentially gone, and they're into Twin America, so there's no need. Right. Okay.
At this point, there's no need. They are shell corporations at this point.
Why did Twin America fail to seek STB approval for the proposed joint venture prior to August of 2009? And these are companies that are sophisticated, have been before the board before. It strikes me anyway, that there should have been an application before this rather than waiting so long. Could you explain that?
Yes, I can explain it, and I can certainly understand the proposition you've raised, Vice Chairman Mulvey. Because Coach USA has been here many times. I've represented them on many of those occasions, in fact, on all of those occasions. But this was a different transaction. It involved different people at the company who were primarily engaged in the sightseeing aspect of the business in New York, totally different folks than those who run the intercity bus operation. So this was a different animal. And they didn't realize that the sightseeing operation was within federal jurisdiction. That's point one. Point two, it was a joint venture, and unlike going out and buying an intercity bus company, which was the standard modus operandi over the years, this was a creation of a joint venture. And again, it didn't occur to them that STB jurisdiction was triggered. It occurred to them only after I explained to them once they hired me. And by the way, I was not involved in the transaction. No, my firm was not involved in the transaction. The lawyers who were involved in the transaction were New York City, and I don't mean to demean them in any way, but they're New York City transaction lawyers. They just didn't understand the regulatory setting, and it didn't occur to them, and it didn't occur to my client that, well, formation of this joint venture would trigger federal jurisdiction. They understand it now. They're sorry. They can't unring that bell. They're sorry they didn't file as they should have before the transaction, but here we are. And there have been, as you know, many instances where parties didn't know, inadvertently didn't know that board jurisdiction was triggered, came in afterwards, and the board has granted those applications.
Well, bus companies have long been horizontally integrated, offering both regular route services as well as charter and tourism and all the like. I came to Washington, D.C. to work for the bus industry for the American Bus Association many years ago. So
I recall.
Go ahead right now. I have a few more questions.
Mr. Coburn, if I could, you just mentioned about the history of counsel in this matter. Can you tell us who was advising your client on the transactional side of this back in the March timeframe, pre-March of 2009, when I think we all agree it would have been desirable if the appropriate filings had been made to this agency as required by law?
It was a small New York City law firm, the name of which I don't know. Perhaps my co-counsel knows the name of that firm. No, it was a small firm that is no longer actively involved.
It was Sullivan and Cromwell?
As far as I know. Sorry?
Sullivan and Cromwell?
It was not Sullivan and Cromwell, no. Trust me, it was a small firm.
Could you provide that for the record?
I'll be happy to provide you the name of that firm.
And if you have the names of the actual attorneys, that'd be helpful too.
Absolutely, I'll be happy to do that. They are not known to me because they're not transportation lawyers. They don't work in the world in which I work. They're deal lawyers who were hired to draft the LLC agreement and deal with that legal aspect of the transaction. And we were not involved. Thank you. It's the firm of Soretsky, Katz, Dranoff, and Glass, and Alan Katz is the lawyer who represented the parties during the transaction. So faced with reduced ridership, faced with challenging economic circumstances, the applicants undertook the transaction as a means of achieving efficiencies needed to meet these challenges and needed to maintain a prosperous business in the face of difficult circumstances. And in fact, they've succeeded in doing that. They are retaining and building a higher and higher level of service than existed before the transaction. Now, the New York Attorney General argues that Twin America has been working hard since March 2009 to bring the transaction within STB jurisdiction. We submit it was within STB jurisdiction at the time it occurred, notwithstanding that no filing was made. The board clearly has authority under 14303 to approve transactions where one entity that already controls more than one carrier assumes control of another carrier. That's exactly the situation here. And transactions in which the transportation assets of two or more carriers are consolidated for operation. Again, that's the situation here. There's nothing suspect about the timing of the transaction and nothing suspect about the application. As I explained, I was retained a few months after the transaction occurred. We did an investigation. We concluded that this was a control situation. We made the filing within weeks after that occurrence. Now, as it happens, the New York Attorney General began his investigation during that period while the application was being prepared, and after we had been retained and after we had decided jointly with the client that it was appropriate to make the filing, in fact required to make the filing at the board. The Attorney General draws conclusions from that timing. I would suggest that's just the way things worked out.
Mr. Coburn,
yes.
With respect to your bringing the transaction, I guess the application under 14303, it wasn't clear which section of that you were bringing under. I know there's A1 through 5, I believe, and this is more of a hypothetical, but let's say hypothetically we found that city sites, we didn't have jurisdiction over them at any time. Would we need to be here today under 14303 since for this transaction to merge in city sites with Coach, with Gray Line?
Yes, we would still be here. We would still have filed an application because Coach USA and Stagecoach, which control other carriers, are attaining control through this joint venture arrangement of a new carrier. That alone triggers 14303.
Okay. And is that's 14303 A5, A1?
That is A4, acquisition of control of at least two carriers by a person that is not a carrier. Coach USA and Stagecoach are actually not carriers. So it's A4, and I think we also fit within A5, acquisition of control of a carrier by a person that is not a carrier but that controls any number of carriers. So there is certainly a jurisdictional hook here, putting aside the city site situation. But for Mr. Marmerstein, there's also a jurisdictional hook because of his control of RW Express, and also he did control city sites, which before the joint venture was an operating carrier, albeit one without the appropriate FMCSA authority.
Mr. Coburn, you mentioned that the reason for this was the declining tourism market in New York City. Did either of these carriers make any attempt at trying to expand their market, capture new business by reducing prices, by cutting prices, to try and make their rather than go the route of merging as a way out of the crisis?
Right. They, in fact, do offer discounts. They offer discounts on a regular basis. If you buy over the Internet, you get, it's either a 5 or a 10% discount.
Were these in response to the declining market conditions, or were these discounts that were always in place?
They were always in place, as far as I know, or at least in place for quite some time. But I think there was some more aggressive discounting as a result of the recession. But there was also a determination that, in fact, Coach USA, or the IBS side of the business, had not raised prices for very many years. I think 4 or 5 years they had not raised prices, other than a fuel surcharge, which came and went depending on the price of fuel. And they actually decided to maintain their revenues, to increase prices, and they did that in a setting where a lot of the tourism business, including transportation tours in New York, and there is an exhibit on this, increased prices modestly, but they did increase prices. They decided to do that in February before the deal, after the transaction. City Sites, or Twin America, I should say, decided that the City Sites side of the business should match what Gray Line had done before the transaction and raised prices modestly. Prices have not gone up since then, and in fact, it continues. Thank you.
Thank you. Next, we will hear from counsel for, I believe, Continental Guest Services Corp. You have 4 minutes. Please step up, introduce yourself for the record, and begin.
Good morning. My name is Mark Berman. I'm from the law firm of Ganford Shore, a small New York law firm representing Continental Guests. For the record, Mr. Alan Katz, who was mentioned by counsel, did appear for the applicants in the New York litigation, representing them at the temporary restraining order hearing. Given my 4 minutes, if you do not mind, I will be reading somewhat from my presentation to get all the pertinent facts in. Continental Guest is over a 100-year-old family-owned company that's involved in the selling of bus tickets in New York City. That's double-decker bus tickets through concierge desks. It is now being exposed to grievous harm because of the anti-competitive consequences directly attributed to the aggregation of the market power of the applicants, at which market power aggregation is now being formalized and entrenched if this application is approved by the board. I speak on behalf of a client on the ground. The first thing that needs to be made clear is that Representative of Twin America has affirmatively stated to my client on multiple occasions that the reason why the applicant is seeking to take over my client's concierge desks is to ensure that another double-decker bus company cannot enter the New York City market. This statement is contained in paragraph 49 of the Zhang affidavit and is not rebutted in any fashion by the applicant in their opposition to the preliminary injunction papers submitted to the New York court. That is the hallmark of anti-competition. The fact is, Mr. Mermelstein had come to my client begging for Continental Guest to sell his company's tickets. Continental Guest could not, because they were in an agreement with the other party seeking application, Gray Line. When that agreement expired, my client decided to actively promote City Sites ticket over Gray Lines. Why? Because City Sites gave my client more of a commission. Now that is, on the other hand, the hallmark of competition. The applicant has made it clear they do not want Continental Guest to be able to do this with any other double-decker bus company in the future that might want to come into New York City. One might ask how that can be effectuated. Continental Guest has 43 desks in hotels in the city. Those hotels control approximately, based on the applicant's numbers in the New York action, 50% of the hotel rooms in New York. That's how it can be effectuated. And that's why Mr. Mermelstein knew when he came to my client years ago why it was so important to offer my client such a high commission. My client made City Sites. The experience of my client provides unequivocal and concrete proof that the concerns articulated by the New York Attorney General regarding the competitive harm likely to result from the aggregation of these bus companies is not theoretical and not speculative.
About what percent of the total charter bus market, the tour bus market rather, in New York is marketed through the concierge desks? Do you have any idea?
I can't tell, because I could tell we have 43 desks, and there are other concierge desks. Some hotels have, some hotels do it in-house, some hotels use other people. So I'm not aware of that.
Aren't there also other places, other venues where you can buy tickets for these tour buses other than the hotels?
Yes, Vice Chairman. There are multiple other places. One would be the hawkers or street sellers. the guys with the vests on the street corners.
Well, it's important because this is I would consider this to be a potential barrier to entry in a market which, on the face of it, would have very, very low barriers. So if this is an important selling point, then that could comprise a very, very serious barrier to market entry for new entrants.
The answer is the evidence of it being a barrier to entry is the factual statement that city sites went and begged to my client, and we put them on the market. They were a small guy running up against Gray Line. How else do you come into New York City but by getting the one source, if you will, that where you have a captive market of all the guests in the hotels in New York City? I understand my time is up. I have not, Mr. Chairman, had the opportunity to go through, if you'd like, I would, with the panel's permission, some of the anti-competitive effects that have resulted post-merge, post-combination, since my client is on the ground.
Thank you, Mr. Chairman. I'd like
I
to
think
ask
we have one more question, and then
I
we'll...
hope you bring out your points as well, Mr. Byrne. But you mentioned your client is located at 43 hotel sites. I mean, rough estimate, how many hotels would you estimate there are in New York City?
Based on the documents provided by the applicants to New York, their lists included 299 hotels. Those 290 hotels represent about 60 some odd thousand rooms. And when you look at the 43 desks that my clients control or lease, those hotels represent about 49% of the 60 some odd thousand hotel rooms based on the charts submitted by the applicants.
In your presentation, you touched on a little bit of the history, recent history, and somewhat recent history in this market. You mentioned your longstanding working relationship with the Gray Line, which I understand had been historically the longtime dominant provider of this type of service.
Coach Gray Line, they were the predominant double-decker tour bus company in New York. That's correct.
And then somewhere along the lines, a new entrant entered the market?
Correct. We had an agreement with Gray Line. We sold their tickets. Sometime down the line, City Sites came to my client, Mr. Mermelston, and said, would you sell my double-decker tour bus tickets? We said no, because we're in an arrangement with Gray Line. When the agreement with Gray Line expired, we then sold to both. City Sites offered my client.
If I could, what happened to Mr. Marmerstein's business when you said no? Was he not able to enter the market at that point, or did he proceed to enter the market?
Do not know the precise timing, but this was in 2007, Mr. Commissioner. I believe that the requests to my client came shortly prior to the termination of the Gray Line agreement, so the period of window was very small. But I can't tell you, factually, what City Sites did during those couple of months. How did they, or did they not enter the market with the anticipation that the agreement was going to end? My client very likely said to them, well, I have an agreement with Gray Line, it's ending in X months. And when the X months expired, they struck a deal.
The record seems to indicate that there is a history here of new entry into this market. And in fact, that's exactly what we've seen, is a new entrant that has actually pulled together a pretty significant team of companies and bundled them together. And it's not, to me, it's not a history of market dominance by one carrier. It's a story of a market that's been successfully penetrated. And it causes me to wonder why anybody who can get their hands on a bus or two, and it has the ambition to go out and work with street hawkers, the internet, and any friendly concierges they can befriend, can enter this market. What's so mysterious or difficult about entering this market?
Well, first of all, we have Gray Line was there for a very long time. I believe the industry and the players in the industry would testify or indicate that when City Sites came on board,
Can you speak up a little bit,
when
please?
City Sites came on board, they needed my clients to promote City Sites tickets over Gray Line. And in fact, what happened is, as a result, is, and I think the numbers would reflect that, using my client as the venue, the distribution channel, City Sites was very, very, very successful. As far as, there's one other double-decker tour bus company, Big Taxi. I think they have 5 buses. in all of New York City. I think perhaps their percentage is 1% or 2%, maybe 3%. The Attorney General would have better information about percentages. But when you look at the applicants, they control well in excess of 90%. So I don't think it's easy to enter. And if it was easy to enter and there was no barrier created, they wouldn't have come to my client begging to use my client's distribution channel as a means to sell their tickets. So I don't think it's easy. And in fact, since Gray Line and since City Sites, you haven't seen another company come in, other than Big Taxi, which has a couple buses and is virtually ineffective.
Just one last question, because Mr. Chairman, you work closely with, it sounds like your client works closely with a number of major hotels in New York City on a daily basis. In your experience or your client's experience, do those hotels make it a practice of referring their guests to tour businesses and tourist businesses that don't provide good service, that are either unsafe or are overcharging their customers? I mean, just in my experience as an individual, guests at hotels, usually you can count on the concierge to give you the straight scoop. They tell you, don't go to that restaurant, they're really overpriced. You probably prefer the one around the corner. I mean, but you're there. I'm not an expert on that area of the business, but
we have 43 desks. We are full service. We've been in business for over 100 years. If we don't do a good job, we don't sell the product. It's unlike other venues. Yourself would go over to the general manager or the reservation desks and say, that concierge over there gave me a bum steer, gave me a crummy restaurant, gave me bad guidance. And you get many of those, you get terminated. So the answer is, if you're doing a good job, you're providing full service, you will be successful in the concierge market. And the fact of the matter is, double-decker tour bus tickets, because of their price point, because of the ability where they're guided, because on nice days they could be outside, because of the hop-on, hop-off attribute of them, and because you could bring your whole family, it is the #1 tourist attraction in the city. Everyone wants to do it. They're all over the place, and a whole family could do it as a reasonable price. The result is, if in fact the applicants stop selling to us, we're no longer full service. If we're no longer full service, the hotels will terminate us, because their guests will come to the concierge and we're going to be able to say, you want a double-decker bus tour ticket? We can't provide it. Go down the street and fight with the hawkers, the street sellers who are on the corners, who right now, post-combination, are fighting with each other about territories, and in fact, right now, post-combination, hassling to the consumer. I understand my time is up. I haven't had an opportunity to give.
Yeah, I had one follow-up question, just final, along the lines of what Chip was asking you. Commissioner Nottingham. Is there a reason your client could not promote a new third company along the lines of what Chip was asking you?
If a third company
came onto the market
to us and said, we're good, we have the services, this is what we offer, our client utilizes everybody. Whether it's sports, double-decker tour buses. If you're quality, we've been around 100 years. If you're well-priced, you do your job, we'll use you. Right now, being on the ground, what has happened post-combination, the lines have gotten longer, the quality has gone down, the prices have gone up, the costs, obviously, with the reduction of my client's commissions have gone down. Result is, with those lower costs, have ticket prices gone down? No. And we view, and of course, without multiple bus companies out there, there's no competition with vis-a-vis us. The fact of the matter is, when it was Greyhound and City Sites and they weren't combined, both offered alternative commission rates. We played one off against the other. That's gone now. They set the unilateral rate. It's take it or leave it.
Thank you, counsel, very much. Next, we'll have counsel for the New York State Attorney General. You have been allotted 16 minutes for your argument. Please step up to the podium, introduce yourself for the record, and begin.
Good morning, Commissioners. My name is James Yoon. I'm an Assistant Attorney General from the Antitrust Bureau of the New York State Attorney General's Office. And with me today is Michael Berlin, Deputy Attorney General, also for Economic Justice, also from the New York Attorney General's Office. You've heard from the applicants about how that different people were involved in the transaction to the joint venture. But I believe Mr. Kinnear and Mr. Moser signed affidavits to the earlier transactions and to this particular joint venture also. So I don't understand why they say different people are involved.
Just for the record, could you explain who those individuals are? Are you talking about attorneys, private attorneys?
No, these are the
individuals,
corporate officers representing Coach USA.
Thank you.
We feel that the joint venture by the applicants harms competition, harms employees, and we believe the STB should deny the application because it is not in the public interest. The effects of this joint venture are not speculative. We've already seen that the prices have gone up. They've even said that after the merger, prices have gone up. They say a little, but it's about 10%. And the services, we've heard from the unions that they've lost wages, lost hours. All these, I believe, harm the consumer ultimately, as well as the employees. The applicants put forth some efficiency justifications for this joint venture. We believe those efficiencies are not outweighed by the anti-competitive effects. Some of these efficiencies that they claim can be done on their own. For example, they say maintenance of buses. I think that's something they can do on their own. Replacing older buses and fixing their older buses, you can do that on your own without this merger. Upgrading a garage, I mean, do you really need a merger to do all of this? I don't think so.
We have this in most industries. When firms merge, they try and consolidate some operations. So there's always some consolidation and to generate some cost savings. So you may have a single garage doing the maintenance, and you may be doing with only 150% of the employees instead of the 200% that there were separately. So there tend to be some of these efficiency economies. But I guess my concern is much more on the entry barriers. I know the AG's office argues that the hop on, hop off double-decker bus market is a unique product, a separate market. But are there really significant barriers to entry in this market? I mean, it seems like almost anybody can buy a bus and get into the market and begin operating.
I think you have to have timely timely manner, sufficient scale, and it has to be likely that there would be entry. So I believe the merger guidelines consider two kinds of entry. There's committed and uncommitted. The uncommitted are, the bus companies that can leave, get a license, have bus stops, but they may leave the next day or a week after.
Contestability theory argues that if you have low barriers to entry, then that itself can be sufficient to keep down prices and create competition, even if there aren't that many competitors. So.
But low barriers to entry, I believe there are other barriers to entry besides just getting a license. As I said, the scale in terms of having, maybe now you'd have to have more than 50 buses, double-decker buses. You'd have to invest in the office. You'd have to invest in the arrangements with the ticket sellers, travel agents, street sellers. As the applicant's economists stated, most of the tickets for Twin America, which means coach and city sites, were sold on the streets through the ticket sellers. All that sort of investment for somebody to come in, I believe, would be very difficult. I believe that would be a barrier. Also, there are regulatory concerns. Currently, New York City is a mature market. There are many more buses than there were a few years ago. people have been complaining about the congestion and the noise, and I know there was a hearing on the New York City Commission on Sightseeing buses to regulate that, so that certainly is a future concern. Also, the applicants cite to the city sites of growing from 8 buses to 70 in 4 years. As I said, the market is a little bit much more mature now, and also I believe in 2003 there was another double-decker bus company, Big Apple New York Tours, that they went out of business, and they were a substantial company. Those assets were later bought by Gray Line, I believe. So I think the barriers to entry are not just getting a license and bus stops. I believe that you won't see another city sites kind of company growing that rapidly. And also timely entry, I think it has to be within 2 years or so. It took city sites 4 years. I believe whoever tries to come in now, unless you have really a lot of substantial amount of capital, it would be very difficult. The other barrier to entry...
Have there been any new entrants since the joint venture began?
I'm not aware of any new entrants that are in that scale or scope. And I believe the applicants have stated that fuel costs are a big part of the costs of operating a sightseeing business. And the applicants in their earlier first application have said that they are going to leverage the, I guess, being part of the Coach USA's company of buses, getting better prices. I believe the volume discounts that they are able to achieve from the economies of scale, a new entrant coming in other than, as I said, an uncommitted entrant, it would be very difficult to sustain.
Mr. Yoon, if I could, frankly, I was a little surprised when I saw that your office was keenly interested in this transaction, but you certainly have I respect the office, and I just want to understand a little more about it. How typical is it for your office to get involved in the tourism market, where you referenced a 10% price increase here? We read regularly in the press that a lot of prices have gone up in New York in the tourism business, sometimes affecting Broadway shows, sometimes affecting cruise line tour operations. I'm a baseball fan, so I'm certainly familiar with the prices at Yankee Stadium and the new Mets Stadium. I mean, do you guys go in? Have you opened up cases in all those areas, looking out to protect the consumers, or is this just kind of out of the ordinary for you?
I guess I wouldn't say out of the ordinary. I guess our concern is certainly we are the tourism business, and the double-decker buses and other forms of tourism are important to us. And I guess our concern was that because the double-decker bus business is unique, 2 major players were getting together. We didn't see any real alternative double-decker bus companies. They have a captive market. They have the market power to unilaterally raise prices, and we felt that it was important to at least investigate the transaction, the joint venture that took place in March. And at that point, I believe there wasn't any scrutiny by anyone at that point, so we just wanted to see what was going on there.
One factor in determining market power is the demand elasticity. And one would assume that since this is not like commutations ride where you need to have access to transportation, this is discretionary, and one would assume, therefore, that demand was much more elastic and therefore much more price sensitive, and that there are some real limits as to how much they can raise rates. Would you agree?
Well, the elasticity, cross elasticity, I believe, it deals with sort of substitutability. So if prices were to increase so that the double-decker riders would go somewhere else, I believe that if there was something substitutable for double-decker buses, you can sort of have that kind of study. But as we've said in our papers, we believe that the double-decker bus market is unique for all the reasons. Number one, geographically, you're going to all the sites in New York City. It's a finite area. The sites that are very popular, the tourist sites, are also similarly finite. They run along the routes where physically you can only have so many buses at one time. The option of getting off on and off these buses looking at the sites, then waiting for another bus to go to the next site. These are all unique properties. I believe that makes this double-decker bus market and the double-decker buses, there are no rental substitutes.
Why couldn't a regular bus do the same thing, run the same routes, stop, allow the hop-on, hop-off service, have a guide who gives, but you wouldn't have the open top, which
Right.
of course isn't very good in the winter or when it's raining. But nonetheless, it could still do the same thing, and I would think that would be an option, even if it wasn't double-decker. You could still have competition from something that is a close substitute. No.
I believe the point of, I guess, riding outside and being at eye level with the sites are very important. I'll give you just a personal example. I rode on one of these buses, and I've lived in New York most of my life, and they were giving a tour about Macy's. And as I was crossing 34th Street, they said the old Macy's is across the street. You can see the old Macy's sign across the street from the new Macy's. And, sure enough, on the wall is a sign, that was former Macy's. I've lived in New York all my life, and I never knew that. But that's something I would have never saw, riding or being down that street level.
I was born and raised in New York, and when I was a kid, they actually had double-decker open-top buses on Fifth Avenue. And so that was actual transportation service, but now you only have the tour buses. So.
Right. And so,
Can I ask you a quick question, just for informational purposes only, but was your state court action that you brought, was that just strictly brought under state law, state antitrust law, or was that federal also?
we didn't bring any action.
Oh, it's just
We have
strictly
not.
an investigation?
Oh, that was the state court action was by a private plaintiff.
Oh,
We have
by-
not brought any action.
Okay.
We are, as you know, we've started an investigation under the Donnelly Act, and we've sort of been investigating with one hand tied behind our backs because the applicants have been, raising jurisdictional issues, and they voluntarily produce documents at their leisure and discretion. I have requests, for example, for since December and January for simple things like the organization chart for Stagecoach.
Has Justice had any issue in this, U.S.?
Justice Department has, I believe they're not involved in this
Okay.
investigation. So as I say, if we're allowed to go through our full investigation, we can take statements under oath, get certified that all documents have been produced to us, and so this actually was referred to us by Justice.
What do you think of their jurisdictional arguments?
The jurisdictional argument, as I've said, the joint venture agreement of March 17, 2009, the joint language of the joint venture agreement itself, as well as the documents that I've cited in the exhibit, all show that it was intrastate, that it was a separate business. This double-decker sightseeing business was not part of their overall interstate business, if they had any. For example, city sites, I believe, did not. I don't think their arguments about the double-decker business being interstate really make sense. The joint venture agreement itself was contemplated within New York City, and I believe the parties may have themselves felt that's why they didn't need to file with the STB, because it was just interstate. I can't speculate, but they've made all these arrangements and through ticketing arrangements, I believe, which are sort of after the joint venture of March 17, 2009, and their economist has stated that the tickets are sold. Most of it are by the street ticket sellers on the street, literally standing on the street. That was in his exhibit. So I believe it's very, very local. The sites are local. These buses don't take. I've not seen a double-decker bus go pick up anyone at the airport. I've not seen anyone go out of state. I think this is purely
get federal preemption? Is that your argument is that it's purely to get federal preemption of the of New York State AG's authority over them, or is that your suspicion?
That the applicants?
Yeah. In other words, they want to preempt the state laws by.
Oh yes, I mean the exhibit that I attached to one of my applications makes clear that they wanted to avoid our scrutiny. I mean, I can't see anything that's.
You say you have an investigation going on, and you've asked us to postpone any decision until you complete your investigation. Do you have any sense of how much longer your investigation would take before it would be completed?
I believe the STB has the authority to decide whether the applicant's business, the double-decker business, is interstate or intrastate, and we've argued, and you've seen our papers, that we believe it's intrastate and that we should be able to continue our investigation. Right now, because the applicants have stated that the STB preempts the New York State AG from going on with its investigation, we've just taken documents and such voluntarily. So, yeah, so we would like the guidance of the STB to determine whether the double-decker bus business is interstate or intrastate. We strongly believe it's intrastate for all the reasons that we've stated, and we hope that if the STB believes that it's interstate, we hope that the STB will deny the applicant's application because it's not in the public interest. Thank you, Commissioners.
Thank you, Counsel. Now, Counsel, for Stagecoach, you have 7 minutes for rebuttal. If I could ask, if we could, I do have some issues with jurisdiction here that were raised by Mr. Yoon, and could you kind of take us through the timeline of when, because it sounds like there was some charter service added, possibly, and I understand your through ticketing arguments. I know there was a trip out to New Jersey, but if you could just kind of take us through the timeline, and because I do have some concerns about jurisdiction here.
Thank you, Mr. Chairman. As part of the transaction, Twin America received 12 standard, not double-decker, but standard motor coaches, the kind you see on the highway all the time, from IBS. Those motor coaches had a history when they were in IBS's control of being used for charter service. When Twin America took them over, that was the logical use. Twin America began, in fact, operating them in charter service, interstate charter service.
When did that start?
There were a few charters operated after the transaction, within a few months after the transaction. That number has been growing as they've been focusing more on the charter side of the business and putting those buses to productive use. I know that in March of this year, they operated about 18 charters, and that's the rate at which they're operating them. The charters go to Atlantic City, they go to Washington, D.C., they go to the casinos in eastern Connecticut, they go to various other places, Philadelphia, etc. So these are...
So you submit as of March 09, when the transaction was signed, that these 12 buses were part of that original transaction, and the intent was always to have this charter service?
That's the best way of using these buses. The buses are sometimes used for sightseeing services, but the sightseeing
they are also used in the double-decker tour.
On rare occasions when they need extra buses, but 9 times out of 10 it's the double-decker buses that operate the sightseeing services, and these motor coaches are used for other services, primarily charter service. And it was because they were operated for charter service that when we were hired, which was in June, of 09, we advised that they needed their own authority to operate these charter buses as charter services. They had been thinking that they could operate them because they had been IBS buses under IBS's operating authority, and we explained that was not a possibility, that they needed, Twin America should have its own authority, it got its own insurance. It advertises the availability of these buses for charter service, and it operates charter service as part of what it does. So there are two sides of the business. There's the sightseeing side of the business, there's the charter side of the business. As far as the sites, and there's one other side, which is that they operate vans to pick people up at certain hotels in New Jersey and bring them into New York City, where they then get on the double-decker sightseeing buses. Well, that van service is across state lines, and it is subject to regulation.
That's all part of Twin America?
That's all part of Twin America. Those vans also.
That started from day one?
From day one.
Van service?
Van service from day one. And that is a continuation of service that IBS was offering pre-transaction. So nothing changed.
And was that in the record in your verified statements?
It is in the record, yes.
Okay.
Yes.
Thank you.
And then, of course, the sightseeing service itself is subject to these joint arrangements with Peter Pan, with other bus companies, including some of the Coach USA companies, with Metro North, a railroad that operates into Connecticut. We have evidence in the record of a through ticketing arrangement with Peter Pan, where you can buy a ticket to go from Connecticut down to New York City, get on a sightseeing bus, do your sightseeing, go home on Peter Pan, all one ticket, one price.
I have a question along those lines. Before the Bus Deregulation Act of 1982, regular route intercity services provided by Greyhound and Trailways were different from the charter and tour operations that were provided by other ones. Now, a company like Gray Line, which focused on local tours in New York City, for example, before 1982, did they need authority from the ICC at that point, or were they strictly regulated by local entities and were therefore exempt from ICC regulation?
I can't speak to Gray Line's situation. I would think if they operated in an area where they crossed state lines, they should have had federal authority. And I know that the Gray Line companies that Coach USA bought back in 1998, as I recall, yeah, it was 98, including Gray Line of New York and GL Bus, which was a Gray Line company. They had federal operating authority. Coach USA bought them. It's a precedent for this proceeding because those were the companies that were operating the double-decker operations, and we explained that back in 1998 when we came to the board and said we want to buy these companies, here's what they do, and the board approved that transaction. And we explained they operate double-decker sightseeing tours in New York. So it's a precedent for this very case.
Mr. Coburn, if I could ask, in your reply brief on page 9, you explain your client's application to this board. The main reason for that is that your client was taking quote, rational and legally required actions as a motor passenger carrier to further its transportation business and to comply with the law. At what point in time should your client have filed with the board to fully comply with the law?
They should have filed, in a perfect world, they should have filed before the transaction and waited the period during which you would have deliberated on their application.
And we would have put that out for comment. We could have heard
yes,
perhaps from the New York Attorney General's office in a timely manner at that time and other parties. Do you see any sense of awkwardness or problem with a regulatory agency at the federal level, such as ourselves, not being able to do our job because we don't even know about the existence of a transaction? And in this case, thank goodness it was not 10, 20 years, but it could have been. We're lucky it wasn't. I mean, years could have gone by before complaints could have risen that would have triggered concerns on the ground in New York, and then we would have learned, wow. Do you see a sense of why we would be concerned with that scenario? We're, in a climate here in Washington where all regulatory agencies are being scrutinized. Or, are we doing our job? Are we protecting the public interest? And here we are. We don't even know about what we're supposed to be regulating because people are failing to disclose that according to the law. And I guess the last part of the question is, are you familiar with some of the civil penalty provisions in Title 49 that apply to parties who fail to file various applications with the board?
We are familiar, Commissioner, and we are respectful of the board, and here we are. I must say that my colleague here representing Continental Guest was not respectful of the board. They did not come before the board, and yet we heard arguments this morning about affidavits that I've never heard of and all sorts of facts that Mr. Berman is throwing into the record. They didn't come before the board. They went right to state court. My client was not a perfect actor here. We acknowledge that. But once they determined that there was a problem, here we are. We came before the board. We filed an application. We're doing the best we can given those facts. And there are lots of situations where, for any number of reasons, we're not the first, where parties have come to the board after a transaction in the railroad area as well as in the bus area, and the board has perhaps slapped the party on the wrist, but where the transaction serves the public interest, that's the ultimate test, the board has approved the transaction. And that's what we submit you should do here. If I may, just there were so many points that were raised, I really didn't get a chance to respond to them. If I have just another minute about barriers to entry, I think the barriers to entry argument is really illustrated so well by City Sites. City Sites started with 8 buses. They quickly grew within 2 years to 50 buses without the cooperation, without an arrangement with Continental Guest Services. Without the concierge service, they grew to 50 buses between 2005 and 2007. It was in 2007 when they first made an arrangement with Continental Guest. So the notion that Continental Guest is somehow, that dealing with them is somehow critical to success it's belied by the fact that about 90% of the sales for these buses is done through street sellers and through the internet. You go on Orbitz, you go on Expedia, you can buy these tickets, and lots of people do. In fact, the hotels only represent about 9% of the sales, and Continental Guest is only it has concierges in 43 hotels out of hundreds.
Mr. Cohen, while you're on that point, can I ask, would your client object to Continental Guest in the future purchasing tickets online, on the internet, or from street hawkers and reselling them?
I think they're free to do that. And so they don't need an arrangement with us to sell tickets. In fact, I walked through Times Square the other day en route to Penn Station, and there are street sellers at every corner trying to sell me tickets on City Sites buses and on Gray Line buses. They're all over the place. And for a new entrant to arrange for street sellers is not a problem. That's
what
not
about the allegation that Mr. Mermelstein has told the concierge group that he wants to buy them out, he wants them to turn over the business for some compensation to Twin America?
Well, I think he did. I'm not fully conversant with the arrangements between the City Sites folks or the Twin America folks and the concierge group. But my understanding is that they did try to buy the concierge group. Nothing wrong with that, and have tried, and that having failed, have tried to set up their own concierge group, perfectly within their contract rights to do that. That'll be tested, I suppose, in a New York court. But
with that kind of vertical integration, they'll begin to develop a barrier to entry. I mean, sometimes you can be fooled by entry barriers. In the aviation industry, everyone assumed that it was very, very low entry, that it was an easy business to get into. But at GAO, we discovered there were a lot of hidden barriers to entry, marketing barriers, et cetera, that new entrants couldn't get into in major airports. And I'm sort of wondering if there aren't some similarities here where on the surface of it looks very, very easy to get into the bus market. Anybody can buy a bus. And yet, on the other hand, because of the marketing situation and the marketing requirements, it really is fairly difficult to get in, as Mr. Yoon has suggested.
Well, again, City Sites grew without the concierge assistance because they represent only a small percentage of the sales, the vast majority of the sales being on the internet and through ticket sellers on the street. So even if you didn't have any opportunity to make arrangements with concierges, and we're far from a situation where City Sites or Twin America is going to control all the concierge desks, but even putting aside the concierge desks, there's lots of opportunity to sell tickets, and that's what City Sites did without the assistance of the concierges. So I don't think this is something for any of us to lose sleep over. I think there's all sorts of opportunity for new entrants and for existing companies to grow their services, and just like City Sites did, on top of which the notion that we're talking about a market here that is confined to just double-decker buses is a false premise. And I think our papers and Dr. Willig's testimony explore that in great detail and demonstrate that the market is in fact a much bigger market that consists of all of the tourism opportunities available to people in New York, not only land tours, but water tours, air tours, and other kinds of attractions where they can spend their tourist dollars.
Thank you.
Thank you, Counsel. I think we're.
If I may, just a clarification for the record, the counsel for Coach USA in the transaction was Robert Okulski of Gibney, Anthony, and Flaherty. The Alan Katz, who I mentioned earlier, was a counsel for the city site side.
Sure. Yeah. Thank you very much, Counsel. And if you would like, I saw that you were reacted to one of the statements, and but just keep it short.
Thank you, Commissioners. I just want to say that the joint venture agreement excluded general charter business. I'm not sure about that, the charter business that the applicants were talking about, number one. And number two, the applicants say that they compete with, Harlem bus tours and boats and whatnot, but their website actually advertises these tours, so I don't think they would advertise a competitor's business.
Thank you, Counsel. Thank you very much for your arguments today, your thoughtful arguments. We will take this matter under advisement, and the meeting of the board is now adjourned.